West Virginia Attorney General JB McCuskey. AG, great to see you. Thank you so much for coming on. So after nearly what seems, I believe, 3.5 hours of arguments, the Supreme Court, it does seem likely to uphold the laws that prohibit biological men and boys from competing on women's and girls' school sports teams. Can you share with, and I know we heard you there in that moment, can you share with what we've heard so far, the line of questioning from the justices and what that says to you, sir?
Yeah, so the justices were incredibly thorough yesterday in both cases. And what we saw was their attempt to try to get the ACLU to explain what their position was. And all we heard from the ACLU was essentially that these laws do not violate Title IX. These laws are not violative of the Equal Protection Clause, but they believe that there is this enormously small subset of people who would be affected by these laws. And that subset of people, sort of strangely, is young children, kids as young as 7 years old, whose parents have decided to begin transitioning them in first and in second grade. And so what they're saying is that if you are able to block puberty for a child who is in first or second grade, that it is unfair to make that boy whose parents have taken all of their testosterone away from playing on the boys' team because they don't have some kind of a competitive advantage because of these medical procedures. And that is, quite frankly, insane.
Let me play this for you and for our viewers. It's a clip of Justice Samuel Alito asking the plaintiff's attorney the seemingly simple question of how they define a man or a woman.
We do not have a definition for the court, and we don't take issue with we're not disputing the definition here. What we're saying is that the way it applies in practice is to exclude birth sex males categorically from women's teams, and that there's a subset of those birth sex males where it doesn't make sense to do so according to the state's own interest.
Well, how can a court determine whether there's discrimination on the basis of sex without knowing what sex means for equal protection purposes?
And I would actually pose that question to you. I mean, it almost seemed rhetorical in that moment. How can you determine discrimination on the basis of sex if you cannot define a man or a woman?
Well, first of all, we know that Justice Brown Jackson didn't define the word sex in her Senate hearing. But what's really interesting there is the contradiction that the ACLU lawyer makes even in her own answer. She says, we don't have a definition of sex, and then goes on to say birth sex males. So she's defining the term in her answer while simultaneously saying that she doesn't have one. And so what they're really looking for is they don't want to tell the court what they think sex is because they know they will lose. And so they're really trying to find an end run around the idea that sex has no definition in the entire language, and we know that's crazy. What we know is that the Congress, when they enacted Title IX, was using the common definition of the word sex as found in Merriam-Webster's dictionary, which is, what are your chromosomes at birth? And that is just a simple, easy definition, and it's a definition that gives us the capability to pass common sense laws that protect women and girls in sports and in all the spaces where size and strength and speed matter.
Information. Truth is freedom. Is Newsmax. It's real news for real people.